Before we begin, a quick and important disclaimer. The following content is provided for educational and entertainment purposes only. This video does not constitute legal, financial, or psychological professional advice. Divorce laws, judicial interpretations, and financial regulations vary significantly by state and individual circumstances. We strongly advise all viewers to conduct their own due diligence and consult with qualified professionals, such as family law attorneys, certified financial planners, or licensed mental health practitioners, before making any decisions related to their personal, legal, or financial affairs. The historical trends and case studies discussed are for academic discourse and do not reflect specific outcomes for any individual viewer. Statistically speaking, in the United States, if you are a man entering or currently in a marriage, you are standing on a structural fault line that most people refuse to acknowledge until the ground begins to shift. According to data from the American Anthropological Association, approximately 70 to 80% of divorces in the U.S. are initiated by women. When we look at college-educated couples, that number surges toward 90%. This is not a coincidence, nor is it a simple matter of personal preference. It is the result of a massive systemic evolution in the American legal and social fabric that has fundamentally altered the landscape of the nuclear family over the last 50 years. For many men, the divorce process feels like a sudden, catastrophic event, but the academic reality suggests it is the culmination of long-term historical trends and institutional shifts that have been in motion since the late 1960s. We are currently witnessing a phenomenon where the traditional expectations of the breadwinner model are clashing with the modern administrative state of the family court system, creating a set of potential outcomes that can leave men financially depleted and socially isolated. This is the silent crisis of the American male in the 21st century. Deep Dive Masterclass is designed to solve one specific, high-stakes problem for you today: the lack of systemic literacy regarding the American divorce machine. Most men navigate their marriages and potential separations using emotional logic, but the system operates on institutional logic. By the end of this 10-part series, you will understand the underlying academic discourse surrounding divorce in the USA, from the economic mechanics of equitable distribution to the psychological theories of male social displacement. We are moving past the surface-level tropes and dive into the data, the case studies, and the historical precedents that define your reality. This first part sets the foundation by deconstructing the initiation gap and the legal framework that governs the modern American household. To understand where we are, we must look at the historical pivot point of 1969. Before this era, the United States operated under a fault-based system. To obtain a divorce, one party had to prove a specific violation of the marital contract, such as adultery, cruelty, or abandonment. This created a high barrier to exit, which statistically favored the stability of the household unit, but often trapped individuals in dysfunctional environments. Everything changed when California, under then-Governor Ronald Reagan, signed the first no-fault divorce law into effect. This legislative shift removed the requirement for proof of wrongdoing, allowing either party to dissolve the union for irreconcilable differences. While this was intended to reduce the bitterness of legal battles, historical trends show it inadvertently shifted the power dynamic of the marriage contract. Academics often refer to this as the unilateral divorce era. In a no-fault system, the person who wants the marriage the least has the most power over its continuation. For men in the USA, this shift meant that the legal protections of the marital contract became significantly more fluid, leading to what sociologists call the marital horizon theory, where the long-term planning of a household is constantly weighed against the ease of exit. The initiation gap is perhaps the most scrutinized area of academic discourse in family sociology today. Why is there such a massive disparity in who files for divorce? Research by sociologists like Margaret Brennig and Douglas Allen suggests that the decision to file is often a rationalized economic and social calculation. Their studies indicate that the primary driver for women filing for divorce isn't necessarily just unhappiness, rather the anticipated outcome regarding child custody. In states where the legal presumption of custody leans heavily toward the mother, the perceived risk of filing is lower for the female party. For the man, however, the historical trends suggest a different set of potential outcomes. Data from the Pew Research Center indicates that men often experience a more significant drop in social support and household stability following a filing. This creates a psychological lag where men are often the last to realize the domestic structure is failing, leading to the common phenomenon of the blindside divorce. Furthermore, we must address the economic architecture of the modern American divorce. In the academic study of law and economics, Marriage is often viewed as a specialized partnership where one party typically invests more in market capital, career and earnings, while the other may invest more in domestic capital. The U.S. legal system utilizes two primary frameworks for dividing this capital: community property and equitable distribution. In community property states like California or Texas, the law generally mandates a 50-50 split of all assets acquired during the marriage. In equitable distribution states, which make up the majority of the U.S., the court has broader discretion to divide assets based on what it deems fair, taking into account factors like the length of the marriage, the age of the parties, and future earning potential. For high-earning men, this often results in a significant transfer of wealth that can impact their retirement trajectory for decades. Historical trends in the U.S. show that while women may see a sharper immediate drop in standard of living post-divorce, men often face a longer-term struggle with wealth accumulation due to the combined impact of asset division, ongoing spousal support, and the loss of the dual income advantage. The psychological dimension of this discourse is equally critical. In many American subcultures, a man's identity is intrinsically tied to his role as a provider and a protector within the family unit. When that unit is dissolved through the administrative process of the court, it often leads to what researchers call a crisis of meaning. Case studies of post-divorce men frequently highlight a pattern of social contraction. In many marriages, the wife acts as the primary social coordinator. When the divorce occurs, the man may find himself disconnected from his previous social circles, leading to increased rates of isolation and health-related issues. This is not merely an anecdotal observation. It is supported by decades of public health data, showing that divorced men in the USA have higher risks of cardiovascular disease and psychological distress compared to their married or single counterparts. As we move forward through this series, we will examine the step-by-step reality of how the family court system operates as an administrative bureaucracy rather than a traditional court of law. We will look at how child support guidelines are calculated using state-mandated formulas that often fail to account for the actual cost of living in high-inflation environments. We will analyze the evolution of alimony from a permanent entitlement to a rehabilitative tool, and how that shift affects men across different age demographics. This is about equipping you with a high-level, academic understanding of the structural forces at play. By looking at the historical trends and the data-driven potential outcomes, you can move from a state of emotional reaction to one of informed awareness. The goal here is clarity. The American divorce landscape is complex, institutional, and often counterintuitive. Understanding the discourse is the first step in navigating the reality of the 21st century male experience in the USA. We are just scratching the surface of the institutional mechanics that define the modern American home and its potential dissolution. In the sections to follow, we will deconstruct the specific legal strategies, financial implications, and social shifts that every man must be aware of to fully grasp the gravity of the academic discourse on divorce. To move from the historical context into the modern legal arena, we must first analyze the strategic maneuvers that define a high-stakes divorce in 2026. The shift from an emotional fallout to an administrative process begins the moment a petition is served. In the academic discourse of family law, this is known as the initiation of the discovery phase. This is not merely a request for information. It is a forensic audit of a man's entire adult life. Imagine a man named David, a 44-year-old project manager in Ohio. David has spent 15 years building a career, contributing to a 401k, and paying down a mortgage on a suburban home. In the eyes of the family court, David is no longer a husband or a father first. He is a set of ledger entries. The first legal strategy we must deconstruct is the doctrine of transmutation. This is one of the most significant financial implications for men who enter marriage with pre-existing assets. Transmutation occurs when separate property, such as a house owned before marriage or an inheritance, is transformed into marital property. Historical trends in the U.S. show that this often happens through commingling. If David used $5,000 of his marital income to repair the roof of the house he owned before the wedding, or if he deposited his premarital savings into a joint account to cover a few months of groceries, the legal distinction between what was mine and what is ours begins to evaporate. Step by step, the court looks for any evidence that the separate asset was supported by marital efforts or funds. Once that threshold is crossed, the asset is often thrown into the pot for equitable distribution, potentially resulting in David losing 50% of an investment he spent a decade building before he even met his spouse. This leads us to the contemporary academic debate surrounding the valuation of intangible assets. In 2026, the definition of marital property has expanded far beyond physical real estate and bank accounts. We are now seeing case studies involving the valuation of professional degrees, career goodwill, and even digital footprints. If David's career trajectory significantly accelerated during the marriage, some jurisdictions allow the court to argue that the spouse is entitled to a portion of his future earning capacity, viewed as a return on the spouse's domestic investment. This is often framed as the human capital theory in academic circles. The argument suggests that because David was able to focus on his career, while his spouse managed the household, the spouse essentially owns a share of David's professional status. This leads to higher alimony awards that are not just based on need, but on the potential outcomes of his future labor. Let us look closer at the financial implications of spousal support, commonly known as alimony. The historical trend has moved away from permanent alimony toward what is called rehabilitative or durational alimony. However, for a man in David's position, the numbers remain staggering. The court utilizes a standard of living analysis. Imagine if David and his wife lived in a high-cost neighborhood, drove luxury vehicles, and took 2 international vacations a year. The court's objective is often to ensure that the lower-earning spouse can maintain a lifestyle as close to the marital standard as possible. This creates a structural paradox. While David's income remains the same, he must now support 2 separate households on a budget that previously supported one. This often results in the payer spouse, usually the man, living at a standard significantly lower than what he provided during the marriage, while the recipient spouse is subsidized to maintain the previous status quo. The social shifts accompanying these legal battles are equally profound and often overlooked in mainstream media. There is a phenomenon academics call social capital depletion. In the U.S., social circles are frequently built around the marital unit. When the divorce begins, a man often finds himself in a state of social displacement. Case studies indicate that social networks tend to gravitate toward the mother in a family unit, especially when children are involved. This isn't just about who gets the friends. It is about the loss of the community infrastructure that supports a man's mental and professional well-being. By 2026, we have seen a rise in the isolation of divorced men, which contributes to a decline in their professional productivity and physical health. The academic discourse suggests that while women often experience a primary economic hit, men experience a secondary, long-term social erosion that is much harder to quantify in court, but equally devastating to their life trajectory. Furthermore, we must address the strategic use of the discovery process as a tool of attrition. In high-conflict cases, the legal strategy often involves an exhaustive search for hidden assets, involving forensic accountants and digital investigators. In 2026, this includes the scrutiny of cryptocurrency wallets, decentralized finance platforms, and even social media archives. If David ever posted about a successful trade or a luxury purchase, that data can be used as evidence of a lifestyle that contradicts his reported income. The cost of this discovery process can easily reach tens of thousands of dollars, effectively draining the very assets the parties are fighting over. This is the exhaustion strategy, where the party with more endurance or less to lose financially uses the legal system to force a settlement. Imagine if David attempts to represent himself or takes a passive approach to these proceedings. The court operates on strict timelines and procedural rules. Failure to disclose an asset, even by mistake, can lead to charges of fraud or the awarding of the entire asset to the other party. The legal framework is designed for efficiency, not necessarily for individual fairness. The academic discourse highlights that men who do not view the divorce through a cold, institutional lens often fall victim to the empathy gap. They expect the system to care about their contributions or their intentions, but the system is a machine designed to redistribute capital and assign custody based on standardized formulas. We are also seeing a shift in how the U.S. public views the role of the provider. Historically, providing for the family was a man's primary social currency. In the 2026 legal landscape, that currency is often spent against him. His high income becomes the baseline for his liabilities, while his time spent at the office is used as evidence of his absence from the domestic sphere, potentially impacting his custody claims. This is the provider's trap. The very behavior that was required to sustain the family during the marriage becomes a liability during its dissolution. The shift in the social contract has led to a growing academic focus on the male experience of the family court system, questioning whether the current statutes have kept pace with the reality of modern, dual-income households. As we conclude this part of our deep dive, we have seen how the legal strategies of transmutation and discovery can fundamentally alter a man's financial future, and how the social shifts of the 21st century can leave him isolated in a system that views him as a source of revenue. But the financial and social aspects are only the beginning of the discourse. The most contentious battle is yet to come. In Part 3, we move into the most emotionally charged and legally intricate domain of the entire process: the mechanics of the child custody war and the automated calculations of child support that determine the next 18 years of your life. We will examine the data behind the best interests of the child standard and how the state's financial incentives often play a hidden role in the determination of your parental rights. You cannot afford to look away now. The child custody battle is the epicenter of the American divorce process, and in 2026, it remains the most legally complex and emotionally taxing phase for men. To understand the gravity of this, we must look at the transition from the historical tender years doctrine, which assumed children were better off with their mothers, to the modern best interests of the child standard. While the terminology sounds equitable, the academic discourse suggests that the application of this standard remains highly subjective and often results in potential outcomes that favor the primary caretaker, a role statistically occupied by women in the majority of U.S. households. Imagine David, our project manager from the previous section, entering a courtroom in 2026. He expects his history of providing and his presence during evenings and weekends to be viewed as equal parenting. However, the legal machine utilizes a multi-factor analysis that looks at the historical status quo of the household, not the aspirational future David wants to build. The best interests of the child standard is not a single rule but a collection of variables. Courts examine the emotional ties between the child and each parent, the capacity of the parent to provide food, clothing, and medical care, the stability of the proposed home environment, and the mental and physical health of all parties involved. In practice, this often creates a step-by-step checklist where a man's professional success can be used against him. If David worked 50 hours a week to fund the family's lifestyle, the court may view his absence from the home during those hours as evidence that he is less bonded with the children than his spouse, who may have worked fewer hours or managed the domestic sphere. This is the structural paradox of the provider role. The very financial stability David provides is used as the justification to limit his custodial time. This brings us to the role of the guardian ad litem or GAL and the forensic psychologist. In contested cases, the court often appoints these third-party professionals to conduct an investigation. This is a forensic deep dive into David's life. The GAL will visit his home, interview his neighbors, speak with his children's teachers, and observe his interactions with his kids. Case studies show that these evaluations can cost between $5,000 and $20,000, added on top of existing legal fees. The academic debate here centers on the immense power these unelected individuals hold. Their recommendations often become the de facto ruling of the court, yet their personal biases regarding traditional gender roles can significantly influence the report. If a GL holds in subconscious belief that young children need their mothers more than their fathers, David is fighting an uphill battle before he even presents his evidence. Simultaneous to the custody war is the calculation of child support, a process that has become almost entirely automated by state-mandated formulas. In 2026, the majority of U.S. states use the income shares model. This model is based on the concept that a child should receive the same proportion of parental income that he or she would have received if the parents lived together. Let us look at the step-by-step mechanics of this calculation for David. First, the court determines the gross income of both parents. This includes salaries, bonuses, dividends, and even certain realized capital gains from cryptocurrency or stock trades. Next, specific deductions are made for taxes and Social Security to arrive at a combined net income. The court then consults a standardized table to determine the basic support obligation. However, the discourse takes a sharp turn when we examine the role of federal funding. Under Title 4D of the Social Security Act, the federal government provides incentive payments to states based on the amount of child support they collect. Academics and legal critics have pointed out that this creates a structural incentive for states to maximize child support awards. If David is ordered to pay $2,000 a month, a portion of the administrative costs to collect and enforce that payment is subsidized by federal tax dollars. This financial architecture ensures that the system remains focused on collection rather than the nuanced reality of shared parenting. When a state increases its child support collections, it increases its federal draw, creating a cycle where the financial interests of the state bureaucracy can align against the movement for 50-50 shared custody. We must also address the controversial discourse surrounding parental alienation. This occurs when one parent systematically denigrates the other to the child, eventually leading the child to reject the targeted parent. While not all jurisdictions officially recognize this as a clinical diagnosis, the behavioral patterns are frequently cited in case studies of high-conflict divorce. For men like David, the risk is that the period between the initial filing and the final decree, which can last 18 to 24 months, allows for a new status quo to settle. If he is limited to alternating weekends during this time, the bond with his children can be intentionally or unintentionally eroded. By the time he reaches a final trial, the court may be hesitant to disrupt the children's routine, effectively rewarding the parent who is able to secure more time at the beginning of the process. Furthermore, the automation of child support in 2026 does not easily account for the rising cost of living or the complexities of modern employment. If David loses his job or takes a pay cut, he cannot simply stop paying support. He must file a motion for modification, which requires a significant change in circumstances and additional legal fees. Until that motion is granted, the original amount continues to accrue as arrears. In the U.S. legal system, child support debt is almost impossible to discharge, even in bankruptcy. It is a prioritized debt that can lead to the suspension of professional licenses, the seizure of passports, and even incarceration. This creates a high-pressure environment where a man's financial life is tied to a rigid, state-enforced formula that prioritizes the flow of capital over the parent's own economic survival. Consider the social shift in how custody is perceived. There is a growing movement in the USA for rebuttable presumption of shared parenting, meaning the law would start with the assumption that 50-50 custody is best unless proven otherwise. As of 2026, several states have moved in this direction, but the institutional resistance remains high. The academic discourse suggests that the legal industry, from attorneys to evaluators, has a financial stake in the adversarial nature of custody battles. If 50-50 were the default, the need for expensive litigation and forensic evaluations would plummet. This conflict between legislative progress and institutional inertia is the terrain David must navigate. Imagine if David is granted the standard visitation schedule of the 1990s, often called the 80-20 split. He becomes a visitor in his children's lives. He is the weekend dad who provides the entertainment but misses the Tuesday night homework sessions, the Wednesday morning doctor visits, and the quiet, everyday moments that build a lasting relationship. The psychological impact on men in this position is profound. Studies show that the loss of the daily parental role is a primary driver of depression and identity crisis in divorced males. They are effectively relegated to a financial utility, a paycheck that arrives once a month, while their domestic influence is systematically minimized. As we conclude this part of our deep dive into the custody and support machine, we have uncovered how subjective standards like best interests of the child can be used to maintain a biased status quo, and how state financial incentives under Title 4D keep the child support numbers high. We have seen how the legal process itself can be used to erode the father-child bond before a final decision is ever made. But the destruction of the domestic unit is only one side of the coin. The other side is the systematic liquidation of the man's financial future. In Part 4, we will dive into the brutal reality of the asset division phase, looking at the forensic methods used to value retirement accounts, business interests, and the devastating impact of the silver divorce trend in the USA. The financial trap is closing, and you need to know how the gears turn. The shift from emotional severance to the liquidation of a man's financial existence is often the most brutal phase of the American divorce machine. In this academic deep dive, we must analyze the mechanics of asset division with forensic precision. In the United States, your financial life is governed by two distinct legal philosophies depending on your state: community property or equitable distribution. While the former suggests a clean 50-50 split, the latter allows the state immense discretion to redistribute wealth based on what a judge deems fair. In 2026, the definition of what is fair has expanded to include assets that many men believe are strictly their own. Imagine a man named Marcus, a 58-year-old software architect living in Virginia. Marcus has spent 30 years in the workforce, methodically contributing to a 401k, managing a diversified portfolio, and building a boutique consulting firm on the side. In 2026, Marcus finds himself in the crosshairs of a silver divorce, a term used by sociologists to describe the skyrocketing divorce rates among those over the age of 50. For Marcus, this is not just a personal tragedy, it's a systematic deconstruction of his retirement security. The first gear in this financial trap is the Qualified Domestic Relations Order, or QDRO. Most men assume that their retirement accounts are protected by federal ERISA laws. However, a QDRO is a specialized legal instrument that allows the court to bypass these protections and hand over a portion of a retirement plan to a former spouse. For Marcus, this means his $800,401,000 is instantly bisected. This is not a simple transfer of cash. The potential outcomes include massive tax liabilities if the order is not drafted with extreme technical accuracy. Furthermore, Marcus loses the most valuable asset in finance, time. At 58, he no longer has 30 years to let compound interest repair the hole left by the court. Historical trends indicate that men in the silver divorce category often have to delay their retirement by a decade or more, or significantly downgrade their standard of living during their elder years. We then move to the academic discourse on business valuation, which is perhaps the most contentious area for entrepreneurs and professionals. Marcus's consulting firm is a service-based business. It has few physical assets, just a laptop and a small office lease. However, in 2026, family courts utilize the concept of enterprise goodwill versus personal goodwill. Enterprise goodwill is the value associated with the business name and its place in the market, which is considered marital property. Personal goodwill is the value tied to Marcus's specific skills and reputation, which in some states is considered separate property. The legal battle often centers on hiring expensive forensic accountants to argue over these intangible percentages. A common and devastating phenomenon in these cases is known as the double dip. This occurs when the court values Marcus's business based on its future income and awards his spouse a percentage of that value as an asset, but then also uses that same future income to calculate Marcus's ongoing alimony obligations. Academically, this is viewed as a form of double counting, yet many jurisdictions still allow it under the guise of equity. Step by step, Marcus is being asked to pay for his business twice. Once as a lump sum in asset division, and again every month in spousal support. The real estate market of 2026 adds a new layer of complexity to this discourse. For decades, the standard procedure was to sell the marital home and split the equity. However, in the current economic climate of high interest rates and the mortgage lock-in effect, this is often a catastrophic financial move. Marcus has a 3% interest rate on his primary residence. If he is forced to sell the home to pay out his spouse's share of the equity, he will have to re-enter the housing market at an 8 or 9% interest rate. This dramatically reduces his purchasing power, often forcing him from a 4-bedroom suburban home into a 1-bedroom apartment, while a significant portion of his equity is swallowed by capital gains taxes and realtor commissions. Some courts may suggest a buyout, where Marcus keeps the house and takes on more debt to pay his spouse, but this often leaves him house-rich and cash-poor, unable to meet his other court-ordered financial obligations. Furthermore, we must examine the historical trends of the silver divorce demographic. Research from the Bowling Green State University's National Center for Family and Marriage Research shows that while the overall divorce rate in the U.S. has stabilized, the rate for those over 50 has tripled since the 1990s. This has led to an academic focus on the longevity hedge. Marriage acts as a hedge against the costs of aging, shared healthcare, shared housing, and shared caregiving. When this unit dissolves late in life, the man often faces a disproportionate social and financial burden. Unlike younger men, he cannot easily pivot into a new career or start a new family. He is effectively liquidated at the peak of his earning years, leaving him vulnerable as he enters the final chapters of his life. There is also the discourse surrounding the discovery of digital assets. In 2026, a man's financial life is no longer just in bank statements. It is in brokerage apps, cryptocurrency hardware wallets, and even non-fungible tokens. The discovery phase now involves specialized digital forensic teams who track blockchain transactions to ensure no marital funds were diverted into decentralized finance platforms. If Marcus made a speculative investment in Bitcoin 5 years ago using marital funds, that asset is now subject to valuation and division, regardless of whether he intended it to be his private safety net. The transparency of the digital age has made it nearly impossible for men to maintain any form of financial autonomy during a divorce proceeding. The cumulative impact of these factors creates what sociologists call the post-divorce wealth gap. While women often suffer a more immediate decline in standard of living, men like Marcus often see a permanent destruction of their net worth. They are left with the liability of high earning potential, but without the assets that were supposed to be the fruit of that labor. The academic reality is that the American divorce system is optimized for the redistribution of current and future wealth, often leaving the primary earner as a high-functioning debtor to the state and his former household. Imagine if Marcus tries to protect himself by liquidating assets early or moving money. The court views this as dissipation of marital assets. In 2026, the penalties for this are severe, including the awarding of 100% of the disputed asset to the other party and potential contempt of court charges. The system is designed to be inescapable once the process is initiated. Every financial move Marcus has made for the last 30 years is now being viewed through the lens of a hostile audit. As we conclude this part of our masterclass, we have seen how the legal doctrines of QDROs, business goodwill, and equitable distribution work in tandem to disassemble a man's financial legacy. We have analyzed the specific risks of the silver divorce and the digital forensic methods used to track every cent. But the loss of money and property is only the physical manifestation of the divorce process. There is a deeper, more insidious transformation occurring beneath the surface. In Part 5, we shift our focus from the wallet to the mind. We will explore the psychological warfare of the divorce process, the academic discourse on male suicide rates post-divorce, and the systemic empathy gap that leaves men without a social or emotional safety net during their most volatile moments. The financial trap has been sprung. Now we look at the human cost. The transition from financial liquidation to psychological erosion is often where the most profound and permanent damage occurs in the American divorce process. In this part of our masterclass, we must analyze the human cost through the lens of academic discourse surrounding male identity, social capital, and the systemic empathy gap that exists in 2026. While the court focuses on the distribution of assets, the man is often undergoing a total deconstruction of his sense of self. To understand this, we return to Marcus, our 58-year-old software architect. For Marcus, the software firm and the suburban home were not just assets. They were the physical manifestations of his role as a provider and a protector. In the academic field of sociology, this is known as identity fusion. When the roles of husband, full-time father, and homeowner are stripped away simultaneously, the individual is left in a state of ontological insecurity. The first psychological factor we must examine is the concept of role exit. For many men in the USA, their primary social currency is their utility. They are valued for what they do rather than who they are. When the divorce decree arrives, Marcus is no longer the head of a household. He is a visitor with a visitation schedule and a monthly obligation. This sudden shift from being the central pillar of a domestic unit to an externalized financial support system creates a profound crisis of meaning. Historical trends indicate that men are significantly more likely than women to tie their entire identity to their marriage and career. Consequently, when one fails, the other often follows in a downward spiral of professional burnout and emotional withdrawal. This brings us to the discourse on the empathy gap. Academics have noted that in 2026, there is a distinct lack of institutional and social support for men navigating the emotional fallout of divorce. While there are numerous public and private resources dedicated to helping women transition into post-divorce life, men are often expected to adhere to the traditional masculine script of stoicism. This is what researchers call the stoic trap. Marcus is told to man up and move on, but he is doing so while facing the greatest psychological stressor of his life. The lack of a socially acceptable outlet for grief or vulnerability leads to what is termed disenfranchised grief, a grief that is not acknowledged or validated by society. The systemic nature of this gap is further evidenced by the statistics on male mortality and mental health post-divorce. Academic discourse frequently cites the alarming historical trends in the USA regarding divorced men. Research published in the Journal of Epidemiology and Community Health suggests that divorced men have a significantly higher risk of mortality from all causes compared to married men. Most strikingly, the suicide rate for divorced men is estimated to be several times higher than that of their married counterparts. This is not just a personal failure. It is the result of a sudden collapse of social capital. Social capital refers to the networks of relationships that provide support and resources. In many American marriages, the wife acts as the social coordinator, maintaining ties with extended family, friends, and the community. When Marcus loses his marriage, he often loses his entire social infrastructure overnight. He realizes he hasn't maintained an independent friendship circle in decades. This leads to profound social isolation, which is a primary driver of depression. Step by step, the isolation feeds into a feedback loop. Marcus feels isolated, which leads to a lack of motivation to socialize, which further deepens the isolation. In the digital landscape of 2026, this is often exacerbated by the algorithm of resentment, where social media feeds can bombard a man with content that validates his bitterness, preventing him from engaging in healthy emotional processing. Furthermore, we must address the phenomenon of litigation stress syndrome. The divorce process is not a single event, but a prolonged period of high-stakes conflict that can last for years. For Marcus, every email from his attorney or notification from a legal portal triggers a physiological fight-or-flight response. This chronic elevation of cortisol has devastating effects on the male body, contributing to cardiovascular issues and cognitive decline. The academic discourse suggests that the adversarial nature of the family court system is essentially a form of state-sanctioned psychological warfare. The constant threat of losing access to children or facing further financial sanctions keeps the man in a state of perpetual hypervigilance. Imagine if Marcus, in the midst of this stress, attempts to reach out for help. He may find that many traditional therapy models are not tailored to the male experience of divorce. Traditional therapy often emphasizes verbal processing of emotions, which may not align with how men like Marcus typically solve problems. Without male-centric support groups or interventions that acknowledge the unique structural challenges men face in the family court system, the potential outcomes often involve the man retreating further into himself. We also see a phenomenon known as secondary loss. This refers to the losses that occur as a result of the primary loss of the marriage. For Marcus, this might include the loss of his relationship with his in-laws, who were his family for 30 years. It might include the loss of his standing in his religious community or his neighborhood. These secondary losses accumulate, creating a weight of grief that is often too heavy to bear in isolation. The academic discourse on male social displacement highlights that for men, the home is often the only place where they feel they can truly relax and be themselves. When that home is lost or becomes a source of conflict, the man loses his psychological sanctuary. In 2026, we are also seeing an evolution in the discourse regarding the masculine identity crisis. As traditional roles are challenged, men are struggling to find a new framework for what it means to be a successful man post-divorce. If the provider role is gone and the protector role is restricted by a court order, who is Marcus? This void is often filled by a sense of purposelessness. The data suggests that men who do not find a new mission or a way to contribute to their community following a divorce are at the highest risk for long-term psychological decline. The cumulative impact of these psychological factors creates a high-stakes environment where a man's mental health is as much at risk as his bank account. The academic reality is that the American divorce system treats the psychological health of the father as a secondary concern, if it considers it at all. This creates a hidden epidemic of male despair that ripples through families and communities. Understanding the depth of this human cost is essential for any academic discourse on the subject, as it reframes divorce not just as a legal transaction, but as a total life crisis that requires a new set of survival skills. As we conclude this part of our deep dive, we have moved from the financial traps into the even more dangerous psychological terrain that men must navigate. We have explored the collapse of identity, the devastating reality of social isolation, and the systemic empathy gap that leaves men without a safety net. But as difficult as the psychological journey is, there is a final, even more combustible element that can be introduced into the litigation process. In Part 6, we move into the darker corners of the legal battle, the strategic use of the nuclear option. We will examine the discourse on false allegations, the tactical use of restraining orders to gain custodial leverage, and how the 2026 legal system handles the intersection of domestic conflict and due process. The psychological pressure was just the beginning. Now we look at how that pressure is weaponized in the courtroom. In the academic discourse of family law, the most polarizing and structurally significant phenomenon is what legal scholars often refer to as the silver bullet. This term describes the strategic use of domestic violence allegations and temporary restraining orders to gain immediate, unilateral leverage in a divorce proceeding. To understand the mechanics of this in 2026, we must look at the procedural framework of the ex parte hearing. This is a legal proceeding where only one party is present to provide testimony. In the interest of public safety, the standard of proof required to issue a temporary order is significantly lower than that of a criminal conviction. It operates on the principle of the preponderance of the evidence, which essentially means the court finds the allegations more likely than not to be true based on a single-sided narrative. Imagine a man named Christopher, a 42-year-old pharmaceutical sales executive living in Charlotte, North Carolina. Christopher has no criminal record, no history of substance abuse, and has been a primary provider for his family for 12 years. In 2026, the definition of domestic harm has expanded in many jurisdictions to include the concept of coercive control. This includes non-physical behavior such as financial monitoring, digital surveillance, or emotional gaslighting. While these laws were designed to protect victims from systemic abuse, the academic discourse focuses on how they are utilized as a tactical opening move. Christopher arrives home on a Tuesday evening to find a sheriff standing in his driveway. He is served with an ex parte domestic violence protection order. In a matter of minutes, the state has exercised its power to remove him from his home, bar him from contacting his children, and seize his legally owned firearms. The immediate potential outcomes of this kick-out order are catastrophic and often irreversible within the context of the litigation. Christopher is forced to find temporary housing, often a hotel or the spare room of a friend. While still being legally obligated to pay the mortgage and utilities on the home, he can no longer enter. He is separated from his personal documents, his professional wardrobe, and his digital hardware. Academically, this is viewed as the creation of a new status quo. By the time Christopher gets his day in court for a full evidentiary hearing, which due to administrative backlogs in 2026, may not occur for 3 to 6 weeks, his spouse has established herself as the sole occupant of the home and the primary caretaker of the children. The court, prioritizing stability for the minors, is historically hesitant to disrupt this newly formed routine. Furthermore, we must analyze the shift in the standard of proof. In a criminal courtroom, Christopher would be protected by the presumption of innocence and the requirement of proof beyond a reasonable doubt. In the family court arena, however, the issuance of a civil protection order is handled with administrative efficiency rather than constitutional rigor. Case studies indicate that once a temporary order is issued, the burden of proof effectively shifts to the defendant to prove a negative. Christopher must now spend thousands of dollars on legal fees to prove that he did not engage in the behaviors alleged. If he fails to overcome the preponderance standard, a permanent order can be entered, which in 2026 carries massive implications for his professional life. The intersection of family law and career stability is where the academic discourse becomes particularly grim for men. In 2026, many corporate HR policies and professional licensing boards have integrated automated background monitoring. A domestic violence protective order, even a civil one, can trigger a review of professional licenses in fields such as healthcare, education, and finance. For a man like Christopher, who requires a clean record to maintain his sales credentials and access to secure medical facilities, the order itself acts as a professional death sentence. Historical trends show that men facing these allegations often experience a secondary loss of employment, which then impacts their ability to pay the very legal fees required to clear their names. This is the structural trap. The legal system requires resources to navigate, but the same system can be used to cut off the source of those resources. We must also address the evolution of coercive control legislation. By 2026, several U.S. states have adopted statutes that define financial abuse as a form of domestic violence. This might include a man questioning a spouse's spending or restricting access to a joint account. While these laws aim to address legitimate abuse, the academic debate centers on their subjectivity. What one party calls financial planning, another can frame as economic coercion. The case study of Christopher highlights how a disagreement over a household budget can be reframed in a legal petition as a pattern of controlling behavior, providing the necessary grounds for an ex parte order. This expansion of the legal definition of abuse has significantly increased the frequency of these filings at the onset of divorce proceedings. The psychological impact of being branded an abuser by the state cannot be overstated. Academics refer to this as social stigmatization and internalized shame. Christopher is now viewed with suspicion by his neighbors, his children's teachers, and even his own extended family. The legal system utilizes a precautionary principle, the idea that it is better to wrongly restrain a man than to fail to protect a potential victim. While this principle is logically sound from a public safety perspective, the academic discourse questions the lack of meaningful recourse for those who are targeted by false or exaggerated claims. In most jurisdictions, there are few, if any, consequences for a party who files a bad faith petition. This lack of accountability creates a moral hazard where the strategic benefits of filing an order far outweigh the risks. Data from the 2020 shows that in highly contested divorces, The presence of a restraining order is one of the strongest predictors of a man losing significant custodial time and a higher percentage of marital assets. It is the ultimate tool of attrition. By the time the case reaches a final settlement, the man is often so emotionally and financially drained from fighting the allegations that he agrees to unfavorable terms just to regain access to his children, or to end the constant threat of incarceration for accidental violations of the order, such as a misdirected text message or an unintentional social media interaction. Imagine if Christopher's case involves digital evidence. In 2026, the use of deepfake technology and manipulated text logs has become a concern in family law. While forensic experts can eventually debunk tampered evidence, the initial ex parte hearing does not allow for a forensic audit. The court acts on the face value of the evidence presented. This creates a window of time where a man's reputation and parental rights can be suspended based on digital fabrications. The potential outcomes of this tech-driven legal environment are only beginning to be understood by the academic community, yet the impact on the ground is already being felt by men across the USA. The academic reality is that the administrative state of the family court prioritizes the mitigation of risk over the nuances of due process. This creates an environment where the nuclear option of a domestic violence filing is not just a shield for the vulnerable, but a sword for the strategic. Understanding this mechanism is vital for any man entering the divorce process, as it represents the single greatest threat to his liberty, his career, and his relationship with his children. As we conclude this part of our masterclass, we have deconstructed the mechanics of the silver bullet and the systemic biases of the ex parte process. We have seen how the expansion of legal definitions like coercive control has created new avenues for tactical litigation. But the weaponization of the law is not the final stage of the discourse. Once the restraining orders are processed and the assets are frozen, the battle moves into the realm of long-term social engineering. In Part 7, we will explore the concept of the fatherless generation by design. We will analyze the academic data on the long-term impact of minimal father involvement on children, the societal push toward the demasculinization of the household, and the growing movement of men who are choosing to opt out of the traditional family structure altogether to avoid these very traps. The legal war is one thing, but the cultural shift is where the future of the American family will be decided. The concept of a fatherless generation by design is not merely a provocative headline, but a significant area of academic inquiry into the structural transformation of the American household. In 2026, we are observing the long-term results of a multi-generational experiment in which the traditional role of the father has been systematically reclassified from an essential co-pilot to a peripheral contributor. To analyze this, we must look at the data-driven consequences of minimal father involvement. According to historical trends documented by the U.S. Census Bureau and various sociological institutes, children from father-absent homes are statistically at a higher risk for a range of adverse outcomes. These include a fourfold increase in the risk of poverty, a higher likelihood of behavioral problems, and significantly increased rates of incarceration and substance abuse. However, the academic discourse in 2026 is moving beyond these raw statistics to ask a more disturbing question. Is the legal system actively incentivizing this outcome? Imagine a man named Ethan, a 30-year-old software developer in Austin, Texas. Ethan is a member of the cohort that sociologists are now calling the Great Hesitation. He has witnessed his older brother, Michael, navigate a high-conflict divorce that resulted in Michael seeing his children only 4 days a month. Ethan observes the mechanics of his brother's life, the high child support payments, the loss of the family home, and the emotional distance that has grown between Michael and his 10-year-old son. For Ethan, this is not just a personal story. It is a case study in risk management. In 2026, the academic discourse suggests that men like Ethan are performing a cold-blooded cost-benefit analysis of marriage and parenthood. The potential outcomes of entering into a legal contract where the exit symptoms are so severe have led to a measurable decline in marriage rates among men under 35. The societal push toward the demasculinization of the household is another critical pillar of this discourse. Academically, this is often discussed as the shift from the authoritative father model to the nurturing assistant model. Historically, the father was seen as the primary link between the family and the external world, providing a specific type of discipline, boundary setting, and risk-taking encouragement that complemented the mother's nurturing role. In 2026, however, the family court system and broader cultural narratives often frame these masculine traits as either unnecessary or, in some extreme academic circles, inherently problematic. This leads to a phenomenon where the state essentially acts as a surrogate father. Through the enforcement of child support and the provision of social safety nets, the administrative state replaces the man's financial and protective utility, effectively rendering his physical presence in the home optional in the eyes of the law. Step by step, we see how this cultural shift influences child development. In 2026, researchers are focusing on the father effect, the unique contributions a father makes to a child's cognitive and social growth. Case studies show that fathers tend to engage in more rough and tumble play, which teaches children how to regulate their emotions and manage physical boundaries. Fathers also tend to use more complex language with toddlers, challenging them to expand their vocabulary. When the legal system limits a man's access to an 80-20 visitation split, it is not just the man who loses, the child loses access to these specific developmental inputs. The academic discourse suggests that we are raising a generation of children who lack the balanced psychological architecture provided by two present and active parents, leading to a surge in what sociologists call the fragile identity epidemic among young males. This environment has given rise to the opt-out phenomenon. In 2026, we are seeing the emergence of a significant demographic of men who are choosing to remain legally single and childless as a survival strategy. This is not merely a lack of interest in relationships, but a calculated response to the legal strategies we discussed in previous parts. These men look at the potential outcomes of the family court system, the loss of assets, the erosion of parental rights, and the psychological trauma of being branded a visitor, and decide that the traditional path is a high-risk investment with diminishing returns. Academically, this is being studied as the birth strike. In the USA, birth rates have reached historic lows, and for the first time, surveys show that a growing percentage of men cite the legal risks of divorce as a primary reason for avoiding marriage and procreation. Furthermore, we must address the economic impact of this mass opting out. The American economy is built on the assumption of a stable, growing population of workers and consumers. When a significant portion of the male population decides to stop forming families, the ripple effects are felt in the housing market, the education sector, and the long-term solvency of Social Security. In 2026, the discourse is shifting toward how to re-incentivize men to participate in the family structure. However, the academic reality is that you cannot incentivize participation in a system that remains structurally adversarial toward one of its primary participants. The historical trends suggest that until the legal framework moves toward a true 50-50 shared parenting default and mitigates the financial devastation of asset division, the opt-out movement will continue to gain momentum. Imagine if Ethan decides to never marry. He focuses entirely on his career, his personal health, and his social circle. He avoids the risk of a 401k bisection and the potential for an ex parte kick-out order. On an individual level, Ethan is protected, but on a societal level, the loss of Ethan as a father and a stable head of a household is a net negative for the community. This is the paradox of the 2026 male experience. What is a rational decision for the individual man is a catastrophic trend for the nation. The academic discourse on the demasculinization of the household suggests that by removing the incentives for men to lead and provide, society has inadvertently triggered a retreat into self-preservation. We must also consider the rise of the digital surrogate. In 2026, many men who are alienated from their children, or who have opted out of fatherhood altogether, are finding community and purpose in digital spaces. This leads to a bifurcation of the male experience. One lived in the physical reality of a diminishing domestic role, and another lived in the virtual reality of shared grievances and philosophical exploration. The danger, as academics point out, is that these digital spaces can become echo chambers that further alienate men from the very institutions that need their involvement. The discourse on the fatherless generation by design highlights that we are at a crossroads. Either we reform the legal and social architecture to value the unique contributions of fathers, or we accept a future where the traditional family unit is a luxury for the few, rather than the foundation for the many. The cumulative impact of these factors creates a society where the male identity is in a state of flux. If a man is no longer a father in the daily sense and no longer a provider in the protected sense, he must find a new reason to build, to protect, and to sacrifice. The current historical trends in the USA show that without a clear, respected role within the family, many men are simply stopping their efforts, leading to what some sociologists call the great male stagnation. As we conclude this part of our masterclass, we have explored the devastating long-term impacts of fatherlessness by design and the rising movement of men opting out of a high-risk system. We have analyzed the developmental cost to children and the economic cost to society. But even as men navigate these cultural and legal minefields, there is one final hurdle that often waits at the end of the divorce process. A hurdle that can prevent any hope of a fresh start. In Part 8, we move into the intricate world of the post-divorce financial hangover. We will deconstruct the reality of life after the decree, the ongoing burden of non-dischargeable debt, the mechanics of wage garnishment, and the specific case studies of men who, despite doing everything right, find themselves in a state of permanent financial servitude to a past they cannot escape. The decree is signed, but the consequences are just beginning. The final signature on a divorce decree is often marketed as the moment of closure, but in the academic discourse of American family law, it is more accurately described as the commencement of the post-judgment administrative phase. This is the stage where the theoretical divisions of the courtroom meet the cold, mathematical reality of the checkbook. For many men in the USA, this period is characterized by what sociologists call permanent financial servitude. To understand the gravity of this, we must deconstruct the mechanics of debt non-dischargeability and the automated enforcement systems that govern a man's income long after he has left the marital home. In 2026, the intersection of high inflation and rigid legal formulas has created a high-stakes environment where one financial misstep can lead to a terminal downward spiral. Imagine a man named Liam, a 46-year-old mid-level logistics manager in Charlotte, North Carolina. Liam earns a respectable salary of $95,000 a year. Following his divorce, the court ordered a combination of child support and rehabilitative spousal support totaling $3,500 per month. On paper, the court determined that Liam had the ability to pay based on his gross income. However, the academic discourse focuses on the gap between gross capacity and net reality. After federal and state taxes, health insurance premiums for his children, which he is legally mandated to maintain, and the mandatory 41% of his take-home pay going to support obligations, Liam is left with approximately $2,200 a month for his own survival. In the 2026 housing market, where the average rent for a modest one-bedroom apartment in a safe area exceeds $1,800, Liam is living on a razor's edge. The first pillar of this financial hangover is the absolute nature of domestic support obligations. Under the United States Bankruptcy Code, specifically Section 523(a)(5), child support and alimony are classified as non-dischargeable debts. This means that unlike credit card debt, medical bills, or even some business loans, these obligations cannot be wiped clean through a Chapter 7 or Chapter 13 bankruptcy. For Liam, this creates a state of financial permanence. If he suffers a medical emergency or a sudden increase in the cost of living, he cannot seek the traditional relief afforded to other debtors. He is, by law, a prioritized debtor to the state and his former household, with no mechanism for a fresh start. This leads us to the mechanics of the Income Withholding Order, or IWO. In 2026, the transition from voluntary payment to automated garnishment is nearly universal. Step by step, the process begins with the court clerk transmitting the order directly to Liam's employer. The employer is then legally required to deduct the support directly from Liam's paycheck before it ever reaches his bank account. While this is framed as a convenience to ensure timely payments, the academic discourse highlights the psychological and professional impact. Liam's HR department and his direct supervisors are now intimately aware of his domestic legal troubles. Historical trends indicate that men under active garnishment orders are often viewed as high-risk employees, which can subtly influence promotion opportunities or retention decisions during corporate restructuring. The IWO transforms Liam's professional identity into that of a state-managed payer. The situation becomes exponentially more complex when we consider the phenomenon of arrears and statutory interest. Imagine if Liam's company undergoes a 2026 tech integration layoff, and he is out of work for 4 months. In the eyes of the family court, his obligation does not stop. It continues to accrue as arrears. In many U.S. states, these arrears carry a mandatory statutory interest rate that can be as high as 10% annually. By the time Liam finds a new position, he may owe an additional $15,000 in back payments and interest. Because child support is a judgment by operation of law, each missed payment becomes a final judgment that cannot be retroactively reduced. Liam cannot simply ask a judge to forgive the debt because he was unemployed. The law strictly prohibits the retroactive modification of child support. He is now trapped in a cycle of debt where he is paying interest on a debt he had no physical way of paying during his period of unemployment. Furthermore, we must analyze the administrative kill switches triggered by non-payment under Title 4D of the Social Security Act. In 2026, the enforcement of support has been fully digitized and integrated across state lines. If Liam falls behind by a certain threshold, typically the equivalent of 3 months of support, a series of automated sanctions are activated. First, his name is submitted to the State Department for passport denial or revocation, effectively trapping him within U.S. borders and potentially jeopardizing any international business travel required for his career. Second, his driver's license and professional certifications are flagged for suspension. For a man whose livelihood depends on his ability to commute or maintain a specialized license, this is a systemic paradox. The state suspends his ability to earn money as a penalty for not having enough money. The academic discourse on the financial hangover also addresses the concept of imputed income. This is a legal fiction where a court decides Liam is capable of earning more than he currently does. If Liam decides to leave his high-stress corporate job to start a lower-paying but more stable career that allows him more time with his children, the court may refuse to lower his support obligations. The judge may rule that Liam is purposefully underemployed and continue to bill him at his previous high-earning rate. This effectively locks Liam into a specific career path and a specific level of stress, regardless of his mental health or personal desires. He is no longer an agent of his own career. He is a functional utility for the fulfillment of a court order. Case studies in 2026 show that this permanent financial pressure leads to a specific type of male social withdrawal, known as economic paralysis. Liam cannot afford to date, he cannot afford to travel, and he cannot afford to invest in his own future. He is working 40 to 60 hours a week to fund a life he is no longer allowed to live. This creates a profound sense of alienation from the fruits of his labor. The historical trends indicate that men in this position often experience a decline in work productivity, which further increases the risk of job loss, completing the catastrophic cycle. We also see the impact on the silver divorce demographic as discussed earlier. For a man who enters this phase in his 50s, the financial hangover is not just a temporary setback. It is a permanent destruction of his ability to age with dignity. Without the ability to save or invest, he becomes entirely dependent on Social Security, which may itself be subject to garnishment if he still owes arrears. The academic reality is that the U.S. system is designed for maximum collection efficiency, but it often fails to account for the long-term sustainability of the payer. Imagine if Liam attempts to challenge these systems. The legal fees to file for a modification of support can range from $3,000 to $7,000. In his current financial state, Liam cannot afford the very legal representation he needs to seek relief. This is the modification barrier. The system assumes a level of financial liquidity that the system itself has drained away. Liam is effectively silenced by his own lack of resources, a victim of the administrative inertia of the 2026 Family Court. As we conclude this part of our masterclass, we have deconstructed the brutal reality of the post-divorce financial hangover. We have seen how non-dischargeable debt, automated garnishment, and administrative sanctions work together to create a state of permanent servitude for men like Liam. We have analyzed the systemic barriers that prevent men from adjusting to economic reality. But even this financial weight is only part of the story. Beyond the money, there is a cultural and legal battleground involving the very definition of what it means to be a man in the modern West. In Part 9, we will dive into the rise of the protective state and the academic discourse on the sunset of traditional patriarchy. We will examine how the shift from familial authority to state authority has fundamentally altered the social contract for men in the USA, and what this means for the future of male leadership. The wallet is empty, but the soul of the social contract is what is truly at stake. The transition from familial authority to the dominance of the administrative state represents the most profound shift in the American social contract since the mid-20th century. To understand the academic discourse on the rise of the protective state, we must look at the legal doctrine of parens patri. Historically, this Latin term, meaning parent of the country, referred to the public policy power of the state to intervene against an abusive or negligent parent. However, in 2026, the application of parens patri has expanded far beyond its original intent. It has become the primary mechanism through which the family court system overrides the traditional authority of the father, effectively placing the state in the role of the ultimate decision-maker for the nuclear family. Imagine a man named James, a 40-year-old civil engineer in Denver, Colorado. James is a father of two who has always been deeply involved in his children's education and medical care. Following a contentious divorce, James discovers that his role as a father has been legally downgraded to that of a consultant, rather than a leader. Under the current legal framework, if James and his former spouse disagree on a significant life decision, such as which school the children should attend or whether they should undergo a specific medical treatment, the state, through a judge or an appointed coordinator, becomes the tiebreaker. This shift from private parental authority to state-managed oversight is what academics call the sunset of traditional patriarchy. In this context, patriarchy does not refer to the common political trope, but to the historical legal status of the head of household as the primary protector and decision-maker for the family unit. The administrative state in 2026 has effectively become the new spouse in many American households. This is not merely a metaphor. It is a structural reality. Through the enforcement of financial transfers and the regulation of parental behavior, the state assumes the functions once reserved for the marital partnership. When the state garnishes James's wages to provide support to his former household, it is performing the distributive role of a provider. When the state mandates that James communicate only through court-monitored digital portals, it is performing the role of a mediator. This creates a psychological environment where James is no longer accountable to a person, but to a bureaucracy. Historical trends show that this transition often leads to a phenomenon known as male disengagement. If James feels that his leadership and authority have been entirely supplanted by a judge, his motivation to invest his emotional and social capital into the family unit often diminishes. This erosion of authority is deeply tied to the rise of the surveillance state in domestic life. In 2026, the legal system utilizes highly sophisticated tools to monitor a man's compliance with court orders. Consider the use of specialized co-parenting apps that are often mandated by the court. These platforms act as a digital record of every interaction, every request, and every dispute. For a man like James, every message he sends is written with the knowledge that a third-party evaluator or a judge may read it months later. This creates a chilling effect on authentic parenting. The academic discourse on this topic suggests that when a man is under constant civil surveillance, his ability to exercise natural leadership is curtailed. He becomes a performer in a legal drama rather than a father in a home. This lack of privacy and autonomy within his own parental role is a primary driver of the identity crisis we discussed in previous parts. Furthermore, we must analyze the shift in the social contract from a trade-off model to a compliance model. Historically, the social contract for men in the USA was based on a specific set of trade-offs. The man provided protection and provision in exchange for authority and the preservation of his legacy within the family. In the 21st century, the state has removed the authority and legacy components while maintaining and even increasing the provision requirements. This has led to what sociologists call the collapse of the provider incentive. If the state can take the provision by force through the IWO system, and the state can remove the authority through the parens patriae doctrine, the rational man begins to question the value of the contract itself. This is why we see the great hesitation among men of James's generation. They are observing a system where they bear 100% of the responsibility, but possess nearly 0% of the final authority. The academic reality is that the protective state views the male figure as a potential risk to be managed, rather than a foundational asset to be supported. This risk management approach is visible in how custody and visitation are structured. The state's default position is often to minimize conflict by separating the parties, which statistically results in the reduction of the father's presence. Case studies indicate that the state prioritizes administrative stability over the nuanced and often messy reality of traditional fatherhood. For James, this means that his desire to be an authoritative leader, teaching his children about risk, discipline, and independence, is often viewed as high-conflict behavior by a court that prefers the path of least resistance. We must also consider the demasculinization of the domestic sphere as a deliberate policy outcome. The academic discourse suggests that the state prefers a model of the family that is more reliant on public institutions than on private male authority. By weakening the independent power of the father, the state ensures that it remains the primary arbiter of social and economic life. This shift has profound implications for the future of male leadership in the USA. If a generation of men is raised in households where the father's authority was non-existent or constantly overruled by a state official, those men are less likely to develop the traits of leadership, accountability, and domestic stewardship. We are witnessing the intentional deconstruction of the traditional male role, in favor of a state-supervised administrative unit. Imagine if James tries to push back against this system by asserting his rights as a father to make a specific choice for his child. In the 2026 legal environment, this is often labeled as an inability to co-parent. The state utilizes the co-parenting standard as a litmus test for custodial fitness. Ironically, the more a man tries to exercise the leadership that was traditionally expected of him, the more likely he is to be viewed as a problem by the administrative machine. This paradox forces men into a state of strategic passivity. They learn that the only way to maintain any access to their children is to surrender their authority and become a compliant subject of the state's domestic policy. The potential outcomes of this systemic shift are only beginning to manifest in our social fabric. We are seeing a rise in what academics call the hollowed-out household, where the financial support is present, but the psychological and cultural weight of the father is absent. The protective state has succeeded in its goal of ensuring financial flow and basic safety, but it has failed to replicate the vital, irreplaceable influence of an autonomous, respected father. The soul of the social contract is not found in the transfer of funds, but in the respect for the man's role as a stakeholder in his own lineage. As we conclude this part of our deep dive, we have explored the rise of the protective state and the resulting sunset of traditional male authority. We have analyzed how the doctrine of parens patriae and digital surveillance have transformed the father into a state-managed utility. We have seen how the collapse of the provider incentive is leading to a massive withdrawal of men from the traditional family structure. But while the situation appears bleak, there is one final chapter to this discourse. In Part 10, we will move from deconstruction to reconstruction. We will examine the emerging strategies for the 21st century man, how to navigate the 2026 legal landscape with a new set of rules, the rise of the sovereign father movement, and the academic path forward for rebuilding a social contract that recognizes the essential value of the male contribution. The system has changed, and now the man must change his approach to survive it. This is the final blueprint for the road ahead. The reconstruction of the male life path in the wake of the American divorce machine requires a shift from a reactive mindset to a proactive, strategic framework. In this final part of our deep dive, we move beyond the deconstruction of the system and into the academic discourse on the 21st century blueprint for male resilience. The reality of 2026 is that while the legal and social structures remain adversarial, the individual man can navigate this terrain by utilizing the very tools the administrative state has perfected: data, strategy, and institutional logic. To understand this transition, we look at a case study involving Alexander, a 35-year-old high-tech consultant in Seattle. Alexander is a member of the generation that has seen the previous 9 parts of this discourse play out in real time. He represents the new model of the informed man. The first pillar of this blueprint is the mastery of alternative dispute resolution, or ADR. In 2026, the academic trend in family law is shifting toward bypassing the traditional courtroom altogether through private mediation and binding arbitration. For Alexander, the strategic advantage of ADR is the removal of the administrative state's direct oversight. By agreeing to a private arbitrator, Alexander and his spouse can select a decision-maker with specific expertise in complex financial structures or child development, rather than leaving their fate to a generalist judge who may handle 50 cases a day. This is not about winning. It is about risk mitigation. Historical trends indicate that settlements reached in ADR are more durable and lead to lower rates of post-judgment litigation. For the man, this means a faster exit from the high-stress environment of the family court and a more predictable set of potential outcomes for his financial and parental future. The second pillar involves the protection of human capital through the lens of economic diversification. In 2026, the savvy man views his career not just as a source of income, but as a mobile asset that must be shielded from the doctrine of imputed income. Alexander's strategy involves maintaining a career path that is highly specialized and difficult for a court to easily replace with a generic salary calculation. Furthermore, the academic discourse on the silver divorce has taught Alexander the importance of the separate property fortress. He avoids the commingling of premarital assets with religious discipline. In 2026, we see a rise in the use of domestic asset protection trusts and prenuptial agreements that are treated with the same forensic rigor as a corporate merger. These are not seen as a lack of trust, but as a necessary component of a modern social contract that recognizes the high failure rate of the traditional marital unit. Step by step, the informed man also addresses the psychological battlefield through the concept of emotional detachment from litigation. Academics call this the bureaucratic stoicism model. When Alexander receives a hostile legal motion or a disparaging communication through a co-parenting app, he does not respond with emotional heat. He treats the communication as a business document. By removing the emotional fuel from the fire, Alexander denies the adversarial system the conflict it needs to sustain itself. Historical trends show that men who adopt this cold, professional demeanor in their legal proceedings are less likely to be targeted by the silver bullet strategies discussed in Part 6. They become hard targets for tactical litigation because they do not provide the reactive evidence that a court uses to justify restrictive orders. The third pillar of the blueprint is the rise of the sovereign father movement. This is an academic and social shift where men reclaim their role as a leader through soft power and consistent excellence, rather than through state-granted authority. Alexander understands that in 2026, his influence on his children is not determined by the number of nights he has on a court calendar, but by the quality and intensity of his presence during his allocated time. He focuses on being an irreplaceable mentor. He engages in what sociologists call high-investment parenting, where he teaches his children skills that the state-run education system and a single-parent household often miss: financial literacy, physical resilience, and critical thinking. By becoming the primary source of high-value wisdom for his children, Alexander ensures that his influence remains intact regardless of the legal status of his marriage. Furthermore, we must analyze the importance of the masculine social infrastructure. In 2026, men are moving away from the isolated, marriage-centric social model and toward the council model. Alexander maintains a tight-knit circle of male peers who act as a private board of advisors. This circle provides the social capital that was previously managed by the spouse. It offers a safety net of emotional support, professional networking, and legal tribal knowledge. Academic discourse on male suicide and depression highlights that men with these independent social structures are significantly more resilient when facing the life-altering stress of a divorce. The council provides the validation and empathy that the state-level system systematically denies, creating a private social contract that offsets the failures of the public one. Imagine if Alexander, despite these preparations, still faces the financial hangover discussed in Part 8. His blueprint includes a contingency plan for economic survival. He utilizes the concept of the lean lifestyle, maintaining a low overhead that allows him to absorb the shocks of support obligations without falling into the debt spiral of arrears. In 2026, we see more men opting for geographic mobility, moving to states with more favorable shared parenting laws or lower costs of living to maximize the utility of their post-divorce income. This is the strategic pivot. If the system in one jurisdiction is rigged toward permanent servitude, the informed man moves his life to a more equitable terrain. The academic reality of 2026 is that the traditional marriage contract is being replaced by a more transactional, transparent model. Men are increasingly demanding what is called the sunset clause in their relationships, pre-agreed terms for a civil exit before the conflict begins. This is the ultimate evolution of the discourse. By acknowledging the potential outcomes of a high-risk union from the beginning, men like Alexander can protect their legacy while still participating in the formation of a family. This is not a retreat from the family unit, but a sophisticated reinforcement of it. The social contract 2.0 is one where the man is a voluntary participant who maintains his autonomy, his assets, and his parental authority through private agreement rather than state reliance. This is the path forward. The historical trends of the last 50 years have shown that the state-managed family model is in a state of terminal decline. The future of the American man lies in the creation of private, high-trust networks and the application of institutional logic to his personal affairs. As we reach the conclusion of this 10-part masterclass, we have traversed the entire landscape of the academic discourse on divorce for men in the USA. We have seen the destruction of assets, the erosion of identity, and the rise of the protective state. But we have also seen the emergence of a new type of man, one who is literate in the mechanics of the system and prepared to navigate it with precision and stoicism. The story of the American man in 2026 is not a tragedy of displacement, but an epic of adaptation. You now have the data, the historical context, and the strategic framework to understand the terrain ahead. The blueprint for the future is being written by those who refuse to be defined by the decree. It is a future of sovereign fatherhood, protected capital, and resilient social circles. The final question remains: as the structures of the old world continue to shift, how will the next generation of men redefine the very concept of the American household? The discourse is far from over, but the tools for survival are now in your hands. This is the end of the beginning. The masterclass is complete, but your application of these truths is just starting. Continue to look for the patterns, stay informed on the evolving statutes, and never forget that in an administrative world, your greatest asset is your informed, strategic mind.